And our first topic for our LexClassroom would be the 2017 Rules on Administrative Cases in the Civil Service. I find this relevant, especially to those students or those viewers now who are working for the government. Now, we have to take notice. The first consideration would be the covered agencies. The covered agencies of the 2017 RACCS are as follows. Actually, we have 8 of them. I'm giving you time to read them, and you have to take note of them because it's possible that you are working in one of these agencies listed. Now, the cases to be heard under or which are covered under the 2017 rules would be classified into two: disciplinary and non-disciplinary. Disciplinary cases are those involving acts or omissions committed by the respondent or the government employee, and there's a complainant and there's a respondent. Okay, aside from this consideration, you have to also consider the jurisdiction of the Civil Service Commission, the regional office, and the disciplining authority. You have to take note also that the disciplining authority has a concurrent jurisdiction with the Civil Service Commission as to the employees working for them. Now, I'm classifying it in my presentation here. The covered agents, the jurisdiction and also the nature of the case. As to the Civil Service Commission disciplinary cases, we have 8 of them. You just have to take note of these items. That's the first half, and in a while I'll be showing you the second half. You have to remember that decisions of the disciplining authority wherein the penalties would exceed 30 days suspension or a fine exceeding 30 days salary, that's covered under the Civil Service Commission disciplinary case. However, it's possible that even if the penalty is below the 30-day period of suspension and also below the 30-day salary as fine, it can still be heard before the Civil Service Commission if the same, it's in our second half of the list, if the same is alleges or there's an allegation that the right to due process was violated. So the civil service can take cognizance of that case. Now, what about non-disciplinary cases? Non-disciplinary cases would involve 6 of them based on my list and based on the 2017 RACCS. You have to take note that um, basically the non-disciplinary cases does not involve a fault or an act or omission or basically non-adversarial. Okay, let's go to the second half of the list. If you look at this, my observation that non-disciplinary cases are non-adversarial. Although there could be an issue or a concern, but just like the um, reassignment, there's no complainant there, but basically the person involved who is being reassigned will be asking for a reconsideration before the Civil Service Commission. What about those cases cognizable before the regional offices? And these are treated as disciplinary cases. You look at it, then you will know the cases I'm talking about. We only have, I'll go back to the slide, we only have 2 disciplinary cases or classes of disciplinary cases that are heard or cognizable before this regional offices of the civil service. Now, as to non-disciplinary cases, these are the list. You have to take note of these 3. However, if you were the complainant and if and when you filed it in the wrong office or venue, you still have a chance that the case will not be dismissed because under the same rules, the agency in which the complaint was originally filed is directed to refer the case to the correct agency. So you just have to take note of that. So you are not hopeless actually. Okay, based on this, I just want you to, I want to discuss what what the rules really provide. It provides the procedure actually in these cases that I'm listing here in my presentation. Actually, these cases or the procedure I've listed are clearly provided in the rules, and I'm advising you to read the full text because what I'm doing now is just a run through of the 2017 RACCS. So it's basically uh, important that you will read the full text so that your knowledge will be widened and you will not just be dependent on our discussion for tonight. Okay, these are the cases. Now, it is very important to know, especially when you become lawyers, you have to be very keen on the procedure, and these are again are clearly provided by our rules. Now, let's go to the things or the items that I consider as salient points or you have to remember. And but before anything else, I just want you to know also that the same rules provides the procedure in non-disciplinary administrative cases so that you will know what you will go through, especially like for example in the list here is the invalidation or disapproval of appointment. What will you do? So at least you are guided on what to do. And I hope you take note of that five items in the list of the non-disciplinary administrative cases. So let's go now to the items that I consider as important. Okay, you have to remember the jurisdiction of the Civil Service Commission, the regional office, and the disciplining authority. However, if the initiatory complaint was filed in the wrong agency, you are not hopeless. As I emphasized a while ago, the agency is directed to refer it to the correct agency. So at least the case will not be dismissed. Okay, the requirements for an anonymous complaint. This is very important because the general rule is that complaints must be verified. So I have here the a salient point that anonymous complaint is allowed under the law, but there should be the element that must be complied with, even if it's not verified. The facts alleged in the anonymous complaint must be of public knowledge. That's one. Or the allegations can be verified or supported by documentary or direct evidence. So there's still a requirement. So at least it's not going to be unfair on the part of the respondent, especially. What about the procedure in sexual harassment cases? This is an incorporation of the policy of the government on gender and development or GAD, because there could be sexual harassment cases left unheard or untouched because of the patriarchal society that we have now. What about preventive suspension? You have to take note of the period as to local government units and local universities and colleges. The maximum period of preventive suspension is 60 days and the rest would be 90 days. You have to take note also that preventive suspension is not considered as a penalty, and the elements that would warrant the imposition of preventive suspension are two. First, if the offense or charge or the acts or omission charge is considered grave, and the second element would be the respondent may or could exert undue influence in the investigation. So he could be placed under preventive suspension so that the investigation will not be tampered with or be marred by bias or prejudice, or marred by, again, there's undue influence, especially for those who are in a higher position. Now, You have to take note also that the respondent or the parties have the option whether they're going to file a position paper. Everything will be in written form, and arguments or counter arguments will be heard in writing. However, as the respondent or the any of the parties, they could also opt to a trial type, in which the rules also provide the procedure. You have to take note also the prohibited pleadings. I have here the list of prohibited pleadings based on the 2017 rules. Number one would be the request for clarification. Sure, you're not allowed to ask for clarification, which is related to the prohibition of bill of particulars. So another prohibited pleading would be the motion to quash, and motions for reconsideration, especially if that's the second motion for reconsideration. And this one, the party or the council must not be guilty of this, the motion for extension. However, there's one instance in which the person or the party is allowed for a postponement, especially if there's a hearing or there's a conflict of in which the council might have an emergency, but the rules only provides a single postponement for each party. So that's one limitation also that must be observed by the parties. I'm sorry if you hear a dog, because I'm opening the windows of my house. um, I'm sorry for that. Now, what about the period of submission of position paper and the investigation report and the decision? You have to take note of all of these periods because, again, motion for extension is not allowed. The investigation report or the formal investigation report will be submitted 15 days upon the expiration or when the proceedings are done. So, the investigating committee or the hearing officer has 15 days. Now, with after submission, within 30 days from that, the disciplining authority must issue his decision on the case. So it's also a prescribed period. Now, you have to also take note of the remedies in case there's a decision issued already. It could be favorable or to the other party, then you are going to appeal or file a petition for review depending on your allegations. Then you also have to take note of the nature of the offenses and the penalties. There are offenses which are punishable by dismissal or for a suspension of a particular period, so you have to take note of this. And you also have to take note of the mitigating and aggravating circumstances that would also modify the extent or the gravity of the penalties or fine um, that is imposed on the respondent. One could be education or the length of service. So I hope tonight you've learned something while you are in your houses, and I want to see you in the next video. And please, again, my advice is for you to read the full text of the 2017 rules on administrative cases. And for the moment that everyone is under home quarantine, please observe physical distancing if you want to go out for food or for medical concerns. And I wish you all the best and be safe, everyone. Have a good night and see you in the next video. Bye bye.